again, just, if you have any queries also, we can ask and clarify. Thanks a lot, and again, welcome to School of Indian, this particular webinar organized by School of Indian Legal Thought. And at the outset, I should also thank Ruben for organizing this particular webinar. Anyway, welcome one and all. I can see a few of my students also. Welcome, and again, many research scholars are there. I think Vishnu is also there. Vishnu Nair is also there. So many of you. So hearty welcome to this webinar. So Aditi, welcome, and we are eagerly waiting for your talk. Thank you.
Thank you. Aditi, you can go ahead. Yes.
Thank you so much, Dr. Gopala Krishnan, and thank you so much, Ruben, for giving me this opportunity to share my thoughts on the knowledge production in international law with you all. So first of all, good morning, everyone. Since the talk is mainly focused at the undergraduate students of law, and this is not something that is traditionally taught at the law schools, I'll try to make things as simple as possible. And if the students here still have any questions, you can write it in the chat box, and maybe we can take that at the end of the session. Okay? So, perfect. So this talk has primarily two aims. Firstly, it is to make students understand how knowledge in the field of international law is produced. And secondly, it is an attempt to get increasing number of students and researchers to realize that there are different ways of thinking about international law. Today's discussion on processes that shape not just international law or any other discipline or field of knowledge for that matter. Michel Foucault famously observed that knowledge is not outside power. For Foucault, power and knowledge are inextricably related, and while knowledge is always an exercise of power, power at the same time is a function of knowledge. Now, in order to understand how knowledge is produced, one can always resort to Foucault's notion of discourse. Discourse is what makes certain statements, practices, and procedures to stay in circulation and others to be excluded. So essentially, discourse makes certain ideas to be legitimized while certain others to be marginalized, right? So one could, I'm sorry, I think, am I visible?
Yes, yes you are.
Ruben, is there a...
Aditi, we can hear you. I think there is a technical problem at the speaker's side. Let me just try and fix it here. Yes. Aditi, can you unmute yourself? I'm trying to unmute you.
Okay.
Yes. Yes.
There is some problem with the internet. Am I audible now?
Yes, yes.
Okay, perfect. I'm so sorry.
That's okay.
Yeah, so we were talking about Foucault's conception of a discourse. Am I audible?
Yes, yes. Yes.
So as I was saying, discourse makes certain ideas or statements or policies to be included in the field of knowledge, while it makes certain other ideas to be excluded or marginalized. So one could say that discourse and discursive policies, which are elaborated by social groups of professionals and grounded on power structures, shape what we mean by international law and set boundaries for what is or what is not a permissible argument within a particular field. Now, if you observe any discipline or field of knowledge, you will see that there is a monopoly of a certain section of academics or professionals over expertise and cultural capital. So international law or any other discipline for that matter becomes the site where this symbiotic relationship between power and knowledge unfolds, and any sign of betrayal from this ideal is actively repressed. So there is a need for reflection on the politics of knowledge production, which is at work in international law and in other disciplines as well. And there is also a need for reflection on the implications of the politics of knowledge on how international law frames and enframes the world. But why do we even need to reflect on the politics of knowledge production, you may ask? Well, no discipline exists in an intellectual vacuum, right? The way in which we understand it, what it does, and what it should do is based on a set of theoretical assumptions and presuppositions, which are not disclosed most of the times. So simply identifying these theoretical assumptions and presuppositions help us better comprehend the nature of that discipline and the biases that may accompany our vision of that discipline or field of knowledge, right? Now, if you talk about international law in particular, until recently, the prevailing conception about the discipline was that it is, some sort of an objective exercise which can be objectively comprehended by the scholars. But nowadays, there is a widespread awareness that what we know as international law is produced by knowledge production mechanisms of a certain nature. So the social phenomenon we qualify as international law is shaped by prevailing discursive policies which are grounded in power structures and which are shaped by epistemic forces.
Okay, I'm sorry, I have to interrupt you. There is somebody who is unmuted themselves. There is a dog barking. I don't know where is that from.
Okay,
Is that from?
I'll quickly see to it. I'm
Yes,
so
yes.
sorry for
Yeah,
the...
that's okay. It's okay.
I'm really sorry.
That's okay. That's okay. We are all at home, so we can try to avoid such circumstances. Please
Yeah,
carry.
the problems with quarantine.
Yes, please carry on.
So, where was I?
You were talking about the objective ideas in international law.
Right, right.
Yeah.
So as I was saying, like until recently, the discipline of international law was thought and seen as some sort of an objective social practice, right? And there was generally the view that it can be objectively apprehended by the scholars. But with time, there is now at least an awareness that the social phenomenon that we understood as international law and what we qualified as international law is shaped by prevailing discursive policies which are grounded in power structures, and these power structures and uh, epistemic forces determine what is acceptable in international law and what is not. Now, how norms come into being has little to do with an objective or a natural process, right? Which norms emerge and in what circumstances is often a result of a dynamic process wherein various actors compete to get their idea of international law legitimized. And this dynamic process of knowledge production is more like a struggle for power between, different actors involved. And this ensemble of actors, which is involved in the dynamic process of knowledge production determine the understanding of what international law is and how it works. And this ensemble of actors is what we call epistemic communities. Now, these epistemic communities provide the correct understanding of international law, thus marginalizing all the alternative understandings and viewpoints about international law. So whether a certain type of knowledge will prevail over another is largely a matter of how the communities favoring one idea of international law above the other will be able to impose their views on a disciplinary discourse, right? Now, some of you might be wondering how these actors or epistemic communities control a disciplinary discourse. Well, one of the processes or one of the procedures for controlling and delimiting the discourse is the culture of the discipline. Now, the members of a discipline are supposed to speak the same language and they share the same values and the same vocabulary or grammar, you may say. Now, which norms emerge and in what circumstances often result from norm entrepreneurs having specific goals, and they use their advocacy strategies to attain their desired normative outcomes, right? So in order to serve their own vested interests, they tend to establish and consolidate their monopoly over the legitimate interpretation of that particular discipline or field of knowledge. Now, too often we regard scientific knowledge production as if it were, some sort of an obvious or uncontroversial exercise. We regard it as something which goes without saying. But that is not the case, and I'll tell you a very short story to demonstrate my point. So, two fish were swimming in an ocean when one said to the other, "Do you know what? I was talking to the frog the other day and he told me that we are surrounded by water. Apparently we live in it." The other fish looked at him with skepticism and said, "Water? What is that? Show me water." So the idea that I wanted to convey through this story is that sometimes the most obvious and ubiquitous important realities that surround us are the ones that are hardest to see and talk about, right? And in a similar fashion, we also tend to ignore that the fact that we also ignore the fact that knowledge is a product of a power struggle between certain actors, and it is a process in which many different factors intervene and then lead to this knowledge production in a particular field. We also tend to ignore that interpretations vary more or less depending on the position of the speaker or writer in the academic hierarchy, right? And in this politics of legal interpretation, the validity of an argument depends on the authority of the academic writer or speaker. Now some of you might be wondering what authority is, and I would like to borrow the definition of authority from Professor Ingo Venski's work, where he calls authority as an actor's capacity to influence and shape meanings, as well as their ability to establish their communications as reference points in a legal discourse. But authority is as much a matter of technical capability as it is of social power. So whoever possesses this form of authority is perceived as being entitled to decide what issues, what theories, and what methods would be relevant to the field, right? So the politics of university appointments or publication strategies or career patterns, and all these factors determine the fate of theories They determine the fate of methods that would be relevant to a particular field, and the theories that would be considered as irrelevant for that field of knowledge. And since we are talking about the culture of a discipline, the key element to foster any change in the disciplinary discourse is the educational system. It is by controlling the academic curriculum and by conquering chairs in prestigious universities around the world that schools of thought can proselytize and direct change. And it is via the educational system that one can secure the permanence of legitimate knowledge by inculcating it systematically in the minds of the students who are going to be next generation of international lawyers, judges, or academics, right? So one of the most important tool in proselytizing this change is international law textbooks. Now, textbooks determine what understanding of international law is correct, and it, you know, inevitably also determines the things that we exclude from our understanding of international law, ensuring that the next generation of international lawyers share not just the same vocabulary and grammar, but more importantly, it ensures that the next generation of students and international lawyers also share the same ignorances and unawarenesses, right? Now, I can go on and on about the role of textbooks in shaping the perception of the new generation of international lawyers, but I'll come back to it in a while. Now, as we were talking about the politics of legal interpretation, another factor on which the validity of an argument depends is its success. Now, the validity of an argument depends on the success and not on its correctness. And only those arguments are successful which have, as Professor Venske calls, law's force on their advantage. Now, law derives its force from narratives, which are dominated by Western knowledge. So those who don't use the vocabulary of traditional or Eurocentric international law would always find themselves at the margins of the knowledge production regime of international legal scholarship. Now, I'll give you an example of an ICJ judgment to show you how the court remains non-receptive to the vocabulary alien to the mainstream or the Western conception of international law. I'm not sure if the students have studied the Libya-Chad territorial dispute case in their course or not.
You can elaborate on the case, Aditi. Aditi? I think there is a connectivity issue there, and she got signed off. Yeah, she's here. Aditi? Yes.
Yeah, I am so sorry.
That's okay. That's okay. I can understand that.
Yeah,
You can touch on the case, yes.
As I was saying, in the Libya-Chad case, Libya relied on the Islamic conception of sovereignty. On the other hand, Chad stuck to the traditional or the mainstream conception of territorial sovereignty. So in this case, Libya claimed that it was naive and self-serving on the part of colonial powers to judge the evidence of autonomous sovereignty on the basis of European standards, right? And Libya also claimed that decentralized power sharing and a sparse control over a territory is also very much assertion of sovereignty under the Islamic conception of sovereignty and boundaries. But the court in this case stuck to the traditional conception of sovereignty, and will find that even in this post-colonial era, the court is still struggling to shed the idea of territorial sovereignty, which originated with colonialism, right? It sets a stage for identity of indigenous tribes to be unconstructed and reconstructed using the Eurocentric concepts and doctrines. But, but you know, human beings don't just exist. They form identities, allegiances, cultures, relationships over a period of decades and centuries. And a judgment embroiled in colonial narratives and doctrines seek to homogenize or civilize the world by imposing non-European relationships that are absolutely alien to the existence or identity of these non-European peoples. Now I would maybe talk a little bit about my research, because my current research is also focused on a similar issue. Well, it aims at attempting to bring to fore the contrast between third world countries and the colonizing powers in legal and semantic understanding of various international legal concepts. And it does so by
Aditi? Hello, Aditi?
included not just ties of territorial sovereignty, but the ties of political allegiance too, right? Stated that confining the nature of legal ties just to the ties of territorial sovereignty would disregard possible relevance of other ties to the decolonization process. And it said so because the main issue of contention in the main issue was in this case was the decolonization of Western Sahara. It was an advisory opinion. It was not a contentious case. So sorry for that. Yeah. So the main contention, the main issue in this case was the decolonization of Western Sahara. So in the court, in a way, tried to be progressive by saying that legal ties just we cannot limit the legal ties to ties of territorial sovereignty, because it might lead to the restricting of the possible decolonization options. But the court still considered the tribe's relationship with land resulting in tribal land rights, but it did not consider it enough for the effective display of Sultan's sovereignty over the territory of Western Sahara. Now, according to the court, the only mode of effective display of sovereignty when it comes to territory was territorial sovereignty. And this case shows that despite the court's desire for responsible heroism, by emancipating the knowledge system of international law from status dominance it ended up judging that the non-Western legal traditions were still in the it, I mean, we still find that in the judgment of the court, non-Western legal traditions were still confined to the same doctrines, the same Western Eurocentric doctrines that the court was actually trying to deconstruct. So the whole practice of ICJ is generally found to be stuck in what I call semantic containment. Now, semantic containment would mean the inability to converse with others unless you're speaking the same language, right? So the international legal language to this day, as I said earlier also, remains non-inclusive of the non-European vocabulary and grammar. I believe someone's mic is unmuted. Okay, so as I was saying, the international legal language is non-inclusive of non-European vocabulary and grammar. And this case is a perfect example for that, because this was exactly what was faced by Mauritania in this case. Mauritania found it impossible to give voice to its peoples in the vocabulary of traditional international law. It found itself unable to describe, by recourse to only Western concepts, the relationship that existed between its rulers and its people. So it contended that the peoples formed of tribes, confederation, as well as emirates jointly exercised co-sovereignty over the country. And such a notion of co-sovereignty is unacceptable and unknown in traditional or mainstream international law. And the court, as I said, failed to consider this non-European conception of co-sovereignty or shared sovereignty. And not just this case, in several other cases I have analyzed, I found that the whole practice of ICJ is stuck in what I just explained, is I believe semantic containment. So basically, I would quickly summarize what I wanted to say is that in the international legal arena, you can't converse with others unless you are using the same vocabulary and the same grammar as the mainstream international law. And it is unfortunate that even in this post-colonial era, the language of international law still remains non-inclusive of the non-European vocabulary and grammar. Now coming back to the issue of politics of knowledge that we were discussing earlier, it is important that we pay attention to narratives. Now, law is a product of commonly shared narratives and other cultural frames that form the basis of how legal principles grow, right? And as I discussed with you earlier, law derives its force from narratives, and these narratives in turn shape our knowledge of what international law is and how it operates. And international law in turn also plays a part in constructive narratives, right? And these narratives determine what we see as problems and and how we devise solutions to these problems. Now, recognizing the narrative function of international law also encourages us to open up to new stories and new and alternative viewpoints regarding international law. Now, I'll give you an example of how knowledge once produced can be embedded in a narrative, circulated, and how it can be used as a means of socialization. Well, the knowledge of international law, which is as I've reiterated several times, dominated by Western understanding of international law, is produced by the ICJ in the form of its judgments, right? And these judgments are widely disseminated and circulated. And then they are referred to and re-referred to by not just the ICJ itself and not just by the international lawyers and the academics, but it is also re-referred to by the domestic courts all around the world. And such stream of knowledge forms into a narrative which further influences behaviors and impacts further knowledge ecosystems. And this is how some of the artificially constructed concepts are naturalized and universally accepted over the course of time. Now, another example of how narratives are used as a strategy for knowledge containment is the usage of textbooks. Now, textbooks around the world represent mainstream or Western understanding of international law as, some sort of undisputed or legitimate knowledge. And the same is circulated amongst the students generation after generation. And these textbooks, written in the tradition of positivist international law, is gradually naturalized as the principal way in which international law should be understood and taught to the future generations as well. So what were once legal imaginations of certain Western scholars and what were once legal imaginations that were aimed at serving the vested interests of certain Western scholars are then naturalized over the course of time, and then they become the principal way in which we understand and talk about international law, right? So that is what I meant when I said that these artificially constructed concepts then become naturalized and universally accepted over the course of time. Now, knowledge production rarely attracts sustained theoretical interest, right? But it is important to realize how important it is in the literature of international law. Well, international legal academics and professionals have traditionally operated on this assumption that, as I said earlier also, that international law is some sort of an objective reality that just exists out there, right? With its own role being limited to providing an accurate representation of that reality. But that is, as I just explained, that is not the case. International law has not formed out of an objective process. It is a result of certain knowledge production mechanisms which involve power struggles between different actors, and there are epistemic communities which, for their own vested interests, sell the idea of a particular international law as correct or the true understanding of international law. And that is also why I encourage not just all the students, but all the teachers and professors of international law also to take interest in the theory of the discipline, and especially in the power struggles that are at work in the field of international law. It is important, I believe, to expose what the brilliant novelist Aditi described as the danger of a single story, right? So the very exercise of considering and exploring alternative frameworks or alternative images of international law should be a part of how the discipline is taught in the law school. Now, most of the traditional international law textbooks referred to by almost all the law schools, not just in India, but around the world, they follow the similar pattern. They have a chapter on sources of international law, on subjects of international law, the relationship between domestic and international law, use of force, and so on and so forth. Now, some of them are now beginning to include a chapter on the critiques of international law at the very end. But most of the teachers just dedicate a lecture or two at the very end of the syllabus on discussing the critiques of international law, which in my opinion is wrong. I don't think we should design the syllabus in the manner that we teach the traditional or Eurocentric conception of international law to the students throughout the semester, and then we just and then we leave the uh, critiques of international law to be taught at the very end. We can discuss more about this if the teachers here are interested in the discussion session that we'll have later on. So what I think is, I want to emphasize here that it is important that we make the students realize that the traditional law that they are studying from the very famous international law textbooks is not as neutral as it would have us to believe, right? The traditional international law has its own assumptions, presuppositions, and cultural biases as well. And these holistic biases or assumptions or presuppositions continue to this day to perpetuate inequalities between global south and global north. And by sticking to the textbooks and scholarships focused just on Eurocentric international law, we are training our students to develop a selective sense of curiosity, right? And here I would like to quote the famous German philosopher Nietzsche, who said that however strong our sight may be, we can only see a certain distance, right? And within that distance, we move and live. So our sight of international law is limited by the way we have been taught, and we are giving the same set of we're giving the same sense of selective view and selective curiosity to our students as well by teaching them what we have been taught and what is essentially just one of the many alternative ideas of what actually international law is. And we by teaching them just this limited understanding of international law, we are gearing our students to ignore and become, unaware of the biases that are actually a part of the traditional or Eurocentric international law. So as I said earlier also, it is important that not just the teachers, but we as not just the students, but we as the teachers of international law also develop interest on how international law is formed, by whom it is formed, and what is it formed for, what were the vested interests behind the formation of a particular doctrine in international law, and so on. Now, all in all, the field of international law, as I said earlier also, is engaged in a power struggle or a power battle in which conflicting claims to academic authority and discursive control are put forward. And while a shift towards changing the vocabulary of traditional international law is well underway, but no set of paradigms have achieved sufficient power to become synonymous with the disciplinary identity, because the disciplinary identity is still synonymous with the Eurocentric international law, even though we have new, alternative conceptions of international law that are being discussed nowadays. Now, there is some hope that new approaches to international law, or the third world approaches to international law, and other critical approaches to international law, like feminism and Marxism and all that, would lead to some change in the disciplinary identity, but it is still a hope till now. And I mean, and that is why it is important that we all contribute to somehow, changing the disciplinary identity by understanding the power struggles that are at work in the formation of international law, right? So I would like to conclude this talk by giving you an example, or giving you an analogy with a spider. Now, if you have observed a spider, a spider can catch only that much which allows itself to be caught within its net, right? So it has a limited scope of what can be, you know, caught by it and eaten by it. So similarly, we have this limited net of knowledge and understanding, and and we need to realize that the limitations of scope of our net disallow us from understanding the limitations of our current engagement with international law. So it is high time that we spread our net and reflect on not just how international law is formed, but we also need to reflect on different theories of international law, their origin, their assumptions, as well as their effect on the research and practice of international law. And with this, I rest my case, hoping that many of you would now show interest in theory, the theory and the knowledge production mechanism of international law. Thank you.
Thank you very much, Aditi. That was a very, very insightful session. Being a teacher of international law, I myself am guilty of just following the syllabus and putting on the back burner this whole idea about critical approaches to international law and also the theories of international law. And the floor is now open for questions. If you have any specific questions based on what Aditi spoke till now, please feel free to raise a hand as a reaction and I can unmute you. Or you can, if you have a question, you can just raise your hand, I'll unmute you. Questions? Or I start with asking a question and the rest of you can just text me as a chat in this box and I'll open you as in when the questions answers are finished by Aditi. So please leave your messages in the chat box. So I'll start with the question. So in international law, we basically start with the sources, and we have the Article 38 of the ICJ statute, where it specifically talks about what are the sources that constitute international law. So having listened to you and about the broader knowledge production process in international law, there is this kind of a difference between the knowledge produced by academics and what is considered to be more authoritative in international law. We seem to tend towards more to the decisions of the ICJ, and that's being propagated back into the academic circle. So how much of an impact can an academician make with regard to finding a concrete concept in international laws? Take, for instance, the third world approaches to international law. And we know that it is still not considered to be mainstream international law. It is considered to be a different approach. Like, I'm wondering how much of an impact the concept of cultural relativism makes when the courts, like you mentioned, the examples of the ICJ, how much of an actual impact does it make in the knowledge produced by these already dominant epistemic communities in international law?
Thank you for such a great question, Ruben. So I agree with a part of what you said, and I disagree with another part of what you said. So I totally agree that the ICJ judgments have a huge role to play in forming narratives and also in framing our understanding of what international law is. But what the point I disagree with you on is that the academics do not have enough say in forming the understanding of international law, because they have. And what is interesting here is which academics have the role to play in determining what international law is and how it forms. So, as I pointed out during my talk also, authority of a speaker or an academic depends on where in the academic hierarchy he or she is placed. So if you belong to a prestigious law school, generally which are mostly based in the US, and you are the chair of international law at a prestigious law school, you definitely have an impact on how knowledge is produced, right? And I can give you an example uh, of how academics have shaped the entire course of what we understand as traditional international law. Now, for example, like since time immemorial, right from Vettel, Grotius, and all those scholars, to present day formation of the doctrine of self-defense, the formation of the doctrine of humanitarian intervention, and if you talk about the very recent formation of this conception of responsibility to protect, that was all a brainchild of academics, right? But as you said, it is the trail or the third world scholars do not have enough say to change the identity of what we understand as international law. And that is again because they do not enjoy enough authority, academic authority, in order to be able to make this change. Now, trail has recently been recognized in the international legal scholarship, and that is because these authoritative academics have started speaking and have started recognizing it as a legitimate approach to international law. It is still not considered as the mainstream approach, but it is considered as now somehow legitimate approach to international law. So it, as I was saying earlier also, it all depends on the politics of university appointments, who is appointed, why. It also depends on the politics of publications. Only the Western scholars mostly find place uh, in the reputed journals of international law, which are considered to be making a change in the identity of international law. I hope I have answered your question.
Yes.
I can go on and on, but I think that is about it.
Yes, that's clear. So we have a question from Aditi. Aditi, she asked, can you give some examples of the alternative approaches to international law?
Okay. Yeah. Thank you for this question, because I think I talked a lot about alternative approaches, but I did not.
Just add to that question, I also have a question, something which is closer to that. And thank you, Aditi. You really shown us how this drawing the boundaries, how it is being defined and redefined through the power structures. And thank you so much for that. And coming to your idea of kind of an alternate or changing disciplinary identities. So within the context of international law, like some other disciplines, I have a kind of a vague idea, but within the discipline of international law, what are the kind of efforts which has been which has been happening to redefine this disciplinary identity? Say, for example, this Marxian idea of internationalism, how much it is kind of an alternate as it taking, especially in the context of post-globalization, or within the context of this new pandemic situation, how it is being influenced, or is there any another stream? Like I'm quite unaware of the stream third world internationalism, which Rubin has just mentioned.
Alternative strands of international legal scholarship which have developed over a course of time, such as third world approaches to international law, legal pluralism, constitutionalism, law and literature, feminism, Marxism. I mean, there are several of these alternative approaches to international law, and some of the critical approaches to international law which strive to bring out the inequalities or the biases in the traditional international law would be third world approaches to international law, feminism, Marxism, and legal pluralism also in a way shows how there are or a lot of conceptions or understandings of what international law is, and there is not just one international law as the traditional international law people or the positivists argue. So I won't talk about all these approaches because that would be an endless discussion. But I would focus on maybe two of the alternative approaches that my work is focused on. So I work on a space which is overlapping of trail and law and literature. So trail or third world approaches to international law, as you were mentioning, unveils the hierarchical nature of international legal system. So it makes critical investigations with a view of unearthing this power relationship and the power struggles which are omnipresent in the international legal scholarship. And Quail scholars denounce the mechanisms used by Western world over time to dominate the third world. This stream of scholarship also analyzes the constant reproduction of colonial structures and forms of domination by Western world to the detriment of the third world, either via formal colonial system or the contemporary forms of neo-colonialism. And I can give you examples of several international legal scholars who are actually working to unearth the power struggles at work and how it is detrimental to the third world countries. We have our own Professor B.S. Chimney, who is fortunately for me, now based at Jindal Global Law School. He is a world-renowned Quail scholar and has done immense work in this field. We also have Professor Antony Angi, Professor Sandhya Pahuja, and several other scholars who are working to, as you said, kind of push towards a certain change in disciplinary identity of international law. And this reminds me of a point which I missed in Rubin's question also, and it is somehow related, that the academics, the immense an important work of the trail scholars and other critical international legal scholars have influenced the judgments of the ICJ as well. So if the court has actually quoted, and another professor, I can't remember the name of, it has articles from Professor B.S. Chimney, Antony Yangi, and all those people. So it has realized, the court has realized that this is now an important stream of knowledge which needs to be considered, and the court has actually taken that into account. In many ways, Chago's judgment is a progressive judgment, and we can see the change in the disciplinary identity happening. But still, there are other problems with the Chago's judgment that I won't go into. But yeah, so we can actually see that happening. Another alternative approach of international law that I'll quickly talk about is law and literature, because it is something that interests me, and whale and law and literature are the fields that I'm currently working on. So law and literature are generally considered two distinct subjects, but they are kind of interconnected because they both talk about the interpretation of text, right? Now, law and literature movement invites lawyers to look at law as a linguistic and cultural practice, which it is. I mean, the positivists or the traditionalists will have us believe that there are two binary distinctions, law and non-law, and that's about it. But that is not the reality, right? We can see law in literature, and we can see law as literature, and that will open up a whole lot of new ideas that we have been missing from the international legal scholarship over the course of time. And some of the professors who are doing some amazing work in the field is Professor Ingo Penske. I'm a huge fan of his work, and I recommend reading some of his work to get an idea of how law and literature are interrelated, and how we can use it in order to unearth these inequalities in international law. And my work is also, kind of influenced from Professor Benske's work on semantic authority. So in my work, I analyze how there is a difference between the legal and semantic understanding of important international legal concepts between the third world nations and the first world countries, and how the ICJ in its various judgments have kind of given more authority to the interpretations of the Western powers, and hence the ICJ judgments we find are mostly tilting towards the Eurocentric conception of international law, and that is what I call semantic containment. As Dr. Arati was asking what I meant by semantic containment. Well, I have derived this term from philosophy, like non-legal philosophy. But what I mean by it is the inability of a person or a state or any actor to converse with others if they are not speaking the same language as the other person, right? So that is what I was saying. This whole international legal scholarship is stuck in semantic containment because non-European peoples are unable to express their relationships, their identities in the traditional international, in the vocabulary of traditional international law, and hence they remain on the margins of knowledge production. Their conceptions are not even considered. I also discussed with you the Libya Chad judgment and the Western judgment, where one of the parties had relied on the Islamic or the non-European conception of sovereignty or the non-European conception of self-determination. But the court failed to consider it and stuck to the traditional conceptions or the Eurocentric conceptions of sovereignty, self-determination, territory, and so on. I hope I have answered your questions, Aditi and Dr. Aditi.
Now we have a question from Anisha. She's a research scholar. Yes, Anisha, you can go ahead and ask the question.
Hi, Aditi. I'm Manisha. See, I have actually put it in the chat box. I don't know whether you have seen my question. Then I would like to ask you clear one thing. It's not like a question. The thing is that once we are, let it be, you are calling it as semantic containment. I understood that. Let it be semantic containment. But should we, can we say that it actually leads to a kind of global consensus in which we need not worry much about the diversity management once we are concentrating to deny the credibility of such a strong, solid Eurocentric international norms that becomes a history now, whether it will be like a historical denial or negationism, which will lead to another unstable paradigm of disturbing the uniform global consensus, because too much critical voices will be competing each other to get into the standard of international law. No, how we are going to manage these diversities once we are going for this kind of historical denial now?
Thank you for this fantastic question, Anisha. If I understand your question correctly, you mean to say that why do we even need to consider these alternate voices? We have an ultimate truth. And why do we even need to discuss if there are alternative approaches?
There's a slight change in it. Even if it is not an ultimate truth, that we have already accepted it as part of history. We know that there are illusions, there are critical thinking, we know that there are flaws. But once we are trying to undo something which becomes already part of our life, then there is always the problem of instability. No, that how we can manage all these things once it is in the international scenario. That is my question.
But it will be like similar to saying, why do we even need to contest the inequality between blacks and whites? Why do we even need to talk about like caste politics and how it affects people? Like that is part of the history, that is part of how we live. Why do we need to contest it? We need to contest it because we need to bring inequalities and power struggles to fore. And because this is international law, you might not see how it is affecting us, but it is. Now, if you read the work of Professor Chimney, he has done some fantastic work showing how international legal rules, especially of WTO, international investment law, and international economic laws, they work towards the detriment of third world countries, and we are suffering constantly because of these rules are biased towards these rules are biased towards the first world nations, and it is detrimental to us. So that is why we need to bring this into fore. Otherwise, I mean, if you're suggesting that we live with these inequalities and we don't highlight this, then I don't think, I mean, that is not the way we should live, right?
No, I'm not telling that we should live with it. We will have to find out the ways to manage the diversities too. Once we are thinking about an alternative like this, which all alternatives should get too much alternative diverse ideas will be competing each other to get into the an international standard with global consensus. Once we are make it open, once the floors are open, then there is always the challenge like this that we are going to face. So obviously we should be equipped to diverse and how to manage all these diversities. That's what. And relating to it, I just would like to raise one more challenge that we are facing. Race is actually embedded in the terms developed, underdeveloped, first world, third world. In itself, the inequality and race is there. That actually makes the critical voices many of the times from the global south is not heard. Because of this, the term itself makes the inequality, and that itself, the race embedded in it. So how can we are forced to be silent. There is a forced silence on our part, on the part of many of the marginal communities and marginal members of the international community. How we can translate this forced silence into a productive addition to the alternative approaches? What any other it's not that easy to, we cannot make our voice. I would like to add one thing to, can the technology be a source that can be very well useful to overcome this this challenge that the global south or the third world countries are facing now?
Thank you, Anisha. You have asked several fantastic questions. The first one was on management of alternative voices. I think it is fantastic that we have as many voices as possible. We can't give right to a particular section of people to just express their views. The right is with everyone, and it's better that more people, come to the fore and speak about their experiences of inequalities, and I think it's better for the discipline as a whole. Secondly, your question about technology, right? I think that is a fantastic question again. I think we can use technology in order to unearth some of the inequalities, and can be a solution to some extent. Uh, for example, when we talk about customary international law, right? Uh, I teach my students how the customary international law has always served and continues to serve and the interests of the global north capitalist countries, right? And if you read the Malcolm Shaw's textbook, which is generally considered the textbook in most of the law schools around the world, he explicitly says that while considering state practice and opinio juris, the activities of the more influential and powerful nations will have greater significance, right? Which is absolutely unacceptable. So I teach students to consider alternative ways of deriving or state practice and opinio juris. So nowadays there are talks among scholars to use data-driven and artificial intelligence-based data sets in order to determine state practice and opinio juris. And technology can be also used to uh, uh, translate the uh, legal documents and the judgments of those countries which do not traditionally produce their documents in English and French, and such countries are generally kept outside uh, uh, the process of the formation of customary international law. And traditionally, only the state practice and opinio juris of only the most powerful states is considered. So we can use big data sets and artificial intelligence to you know uh, uh, bring more equality to the process of the derivation of customary international law. It is just one of the examples. We can use technology in other areas as well. And another question you asked was regarding labels. Like we use labels such as global north, global south, third world countries and first world countries. And I understand the problems with labels, and I did not talk about the politics of language today, but but there is this huge problem that arises due to framing and the framing of the language, the way it is framed, and the labeling uh, of peoples and concepts and states. And I totally understand your point, and we need to realize the problem with labels and frames, and we need to work around them, or we need to highlight that also. So that is all I have to say about that. I hope I have answered your questions.
Yeah. Thank you, Aditi. And it was actually a nice presentation and thought-provoking ideas. Thank you so much.
Thank you. Thank you.
Yes, now we have a question from Ajit Kodara. He had posted in the chat box, but I'm not able to retrieve it. Ajit, can you ask your question? Okay, I'm not getting a response from Ajit.
You want me to read, Robin?
Sorry?
You want me to read that?
Yes, please. Yes.
Yeah. It's hi Aditi. How can we, as students of law, ensure that we get an unbiased knowledge about the international laws? What material sources approach would you recommend in that regard?
That is a really good question. So, firstly, I think the onus is on us teachers who teach international law to not just stick to the traditional approaches to international law. So, like, I've been teaching for just 2 semesters now, and this was the first time. This ongoing semester was the first time when I taught international law. So, what I used to do in my class was I used to teach the critiques of international law parallelly with you know the 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 main topics. So while discussing the sources of international law, I also discussed its critiques and so on and so forth. But like moving forward, I think, I mean, there are problems with this approach also. So I think I'm no, I'm a new teacher and I'm no authority, but what I feel would be a better way of teaching and learning international law would be to teach the diachrony of international legal concepts. So we can teach how different international legal concepts have changed over a course of time, right? How their meanings have changed, how their interpretations have changed, and what were the factors that led to these changes in the interpretation of these international legal concepts. That way, I think the students will understand the meaning of these terms, but they'll also realize how knowledge is produced and who are the actors responsible for uh, uh, producing this knowledge and how international law as a whole works. Now, if you talk about materials, I think sticking to a traditional textbook like Malcolm Shaw would not do. You will have to read a lot more on critical approaches to international law. So that is what I was saying. We need to develop interest in the theories of international law, and it will depend on you which theories you would like to associate yourself with. So you might find Marxism or ideas of feminism, or maybe Trail or legal pluralism closer to your thoughts. So you'll have to read a lot about these approaches, like alternative approaches to international law, and over time only you will realize what ideas you would like to associate yourself with. So as I gave the spider example earlier, you'll have to spread your net in order to be receptive to alternative approaches to international law as well. I hope I answered your question.
Yes, but yes. He's not able to, I think, unmute himself, but I think you have sufficiently answered that question. Now we have a question from Shivraj. It's a very relevant question. Shivraj, do you want to unmute and ask yourself, or else I can ask this question? Okay. Shivraj has asked, what are your views on Italian Marines case, the Permanent Court of Arbitration's award that was passed yesterday? Do you consider it as India's defeat?
Well, to be honest, I haven't read much about the case. I just know the facts superficially, and I haven't gone through the judgment that was passed yesterday. Uh, I'm not sure if it is a defeat for India. I mean, I find myself unable to comment on this since I don't have maybe enough knowledge on the subject. Maybe we can, if you're interested, I can read up more on it and we can have a chat later on. So I'll leave my email address below.
No, on that question, Aditi, I think because the aspect of compensation was already agreed by the Italian government, I think it was around 1 crore for the victim's family each, and the arbitration judgment was more on. You cannot say that it was India's defeat, but I see that India was at a position that was not at par with that of the Italian position. So there is an interesting analogy here, like how India, which is a third world country, is pitted against a European power. So there is also this question of jurisdiction that came into the arbitration that was going on. So there was this conclusion that India doesn't have criminal jurisdiction over the Italian Marines, and also that even if the ship was within the territorial waters of India, or within the limit of Indian seas, they were still in the ship which was considered to be Italian territory. So this was something which is going on till from the SS Lotus case, right? That territorial idea of territorial sovereignty, and the flag bearing state having the sovereignty of this issue. So how do you see the idea of sovereignty? We know that the idea of sovereignty has come a long way, and it has undergone lots of changes. But how do you see the influence of politics, international politics, global politics, when it comes to a question of international law between a global South nation and the global North country?
That is an interesting question. Of course, the idea of sovereignty has changed over time, and as you must be aware that the idea of sovereignty is traditionally associated with territory. So what is considered as sovereignty is actually, territorial sovereignty. And as you must be aware, such a conception originated with colonialism, because that was interpreted or made that way in order to serve the interests of the colonial powers. Now, over time, we find that even like if you talk about history, the idea of sovereignty has come a long way. But if we talk about changes in the idea of sovereignty after maybe the Second World War, or after the formation of United Nations, it hasn't changed much, unfortunately. And as I gave you the example of the Western Sahara judgment, the court tried to be progressive, and the court tried to consider, political allegiances and known territorial ties as forming as resulting in ties of sovereignty between the peoples of Western Sahara and the rulers of Western Sahara. But ultimately stuck to the idea of territorial sovereignty. So in my understanding, as far as the analysis of the ICJ judgments is concerned and other works of academics is concerned, I don't think there has been much change in the idea of Eurocentric or mainstream international law since the formation of the United Nations. Am I audible?
Yes, yes, Aditi. Can you just detail a bit on the involvement of the UN that you were mentioning? I think I missed that part. I'm not sure if everyone is able to catch that, but it'll be good if you can repeat the UN involvement part.
Okay, I was just saying that I agree with you that the concept of sovereignty has changed over the course of time. The idea of sovereignty has changed several times, and there is a fantastic article enlisting all the changes in the idea of sovereignty by Professor Samantha Besson. So if you would like to read that. But in my opinion, after the formation of United Nations, so after the Second World War, I don't think there have been like changes in the conception of sovereignty. It is still meant to be territorial sovereignty. So as far as my understanding of the judgments of ICJ is concerned and works of other academics is concerned, I don't think the international legal scholarship has been able to come out of this idea of territorial sovereignty. Again and again, we see in different ICJ judgments, from Western Sahara case to Libya Chad case and all the other territorial or other disputes, the court is still stuck in the traditional concept of sovereignty. And even though, like I just said, in the Western Sahara case, the court tried to be progressive and it tried to be receptive of the African conception of sovereignty. It tried to consider the non-territorial links between people and the rulers as ties of political sovereignty. But if you read the reasoning of the court, it later on decided to stick just to the territorial conception of sovereignty. So I was just saying that even though, as you said, the concept of sovereignty has changed over time, the meanings have progressed, but I don't see much change in the idea after, especially the formation of United Nations.
Yes. I would like to add just a clarification there. Yes, I agree with you on the territorial sovereignty aspect, but then the change that has happened to the idea of sovereignty is that states have come more under the rule of law. Like you mentioned, the concept of responsibility to protect. So that was my question about politics and international law, how these big superpowers are able to enforce their political influence on the less powerful states and make an influence on how it is formalized in their territory. How the laws of war have changed over the years. Like earlier, countries were able to just do whatever they wanted to do in war, and now it is regulated by the humanitarian law. And we also have the international criminal law. So states are more or less coming under the rule of law. But then we can also see situations like where the concept of use of force is utilized by countries like America, like to cater to their vested interest in the name of national security. So that was my question about how the balance of political powers with regard to international law formation.
That is a fantastic point, and I am sorry I did not mention the politics that you were talking about in the last part, in my last answer. So, as you said, I to a point agree that almost all the states are now coming under the rule of law. But again, what is law? Law is what serves the interests of the first world nations. Law is what serves the interests of these Western powers. So the doctrine of, whether it may be the doctrine of humanitarian intervention or the doctrine of responsibility to protect it, but they were actually devised in order to serve their interests, right? You may call it a rule of law, but again, we need to realize who has developed that law and whose interests it is serving. So, for example, the US will have us believe that the bombing of Iraq was humanitarian intervention and it was done for the larger good of humanity. But I think everybody now knows that it was not the truth. Not the truth. And I think what we need to consider is not just the politics of knowledge production, but also this linkage between power, knowledge, and media, right? So the first world countries do not just have control over the knowledge production processes, but they also have control over the world media. So they broadcast what they want the world to believe. Like it was constantly broadcasted that people are being killed in Iraq, and they pose a threat to the humanity as a whole, and we need to act. This was said over and over and over again. That was broadcasted, and obviously they also devised this law of humanitarian intervention to serve their interests. So, I mean, that is what I've been talking about throughout, that we need to realize how knowledge is produced, by whom it is produced, and whose interests it is serving, and who is it detrimental to, right? In order to expose the inequalities it is leading to. I hope I have been able to answer your question. And another example would be 9/11, right? Like millions of people have been dying every day in the Middle East, in Africa, and elsewhere in the world. But once a couple thousand people die in the US, and suddenly it is the most unprecedented event that has happened in the history of mankind.
Yes.
So that is how and now we talk about post 9/11 era. So many things changed after 9/11. They developed so many new doctrines in international law in order to serve their interests, because it was made to believe to the world that it was something unprecedented and something of the sort had never happened, even though people have continued to be killed in different parts of the world. It's just that they were not being killed in the US or Europe.
Yes, exactly. Like some other instances to add to it, that it's also very important that the powers that are involved in these kind of instances also acknowledge their involvement, because the intervention in Syria by US, UK, and France. After that, it was only the UK that made an acknowledgement of legal justification for the intervention in Syria. The US and the French were silent about the intervention. So you can see that sort of silence is also there with regard to these power disparity between countries. And in this global politics, you can see that countries promoting ideologies, and so that the media manipulates it and makes it to the interest of the nation that is propagating these ideas, like the ideological war between China and the US with regard to climate change and the cutting down of global emissions. You can see politics at play here. And the outcome of these conventions and protocols are mostly based on the political discourse that happens at these summits. So it is a very relevant consideration that we have in knowledge production, the intercourse between power, knowledge, and media. So thank you for that answer. Any other questions? Yes. If we don't have any questions, we can wind it up. It's 12:15. So, Dr. Aditi, do you want to add something?
No, I was just thinking, I'm just a student of international law, I would say, because I just started teaching human rights law. Other than that, I have no, like, I was a student before, other than that, nothing to do with. But I was thinking, like, the changing roles of UN, including WHO, and the role of corporate interest and multinational companies and their interests, which goes much beyond the notion of territorial sovereignty, which is they are defining the interest of territorial sovereignty, and they are capable of something which can manipulate and take decisions on behalf of nation states. So when we think about territorial sovereignty today, I think we have to consider the interest of market forces as well as these kind of corporate interests, which are actually redefining the roles of UN organs, including WHO, UNICEF, and all. So I was thinking, how do we see the role of market here?
I think you have a very relevant and fantastic point here. Economics and market is what derive the world today. We are in this capitalist world, and if you, I mean, I'm not an expert in the field, but if you want to read more about this, there is this alternative strand of knowledge in international law which solely focuses on law and economics. And obviously we can see the role of economics and market in play, like throughout the international legal arena. So whether it may be WTO or the UN or the other international organizations as well, this is what, you know, divides this is what determines the difference in powers and the balance of powers in all these international organizations. Now, if you talk about Security Council, I mean, why do just like 5 first world countries have the right to veto in the Security Council? Why are just the 5 members permanent members, right? Similarly, even in the IMF and the World Bank, the voting rights depend on the economic power of a particular country and how much it is contributing to that international organization. So it is obvious that a state like Belize or Uganda will never have enough economic power to be able to have a say in the formation of any of the decisions in these international organizations. So that is very much a problem. And as I stated earlier also, I mean, this is economics and market is what determines how knowledge is produced. So we have, I think I stated this earlier also, the rules of WTO and international investment and economic laws. These all rules are, you know, detrimental to the third world states, and they are biased in favor of the first world nations. And it is so because these are the powers responsible for making these rules. The third world states did not have a say in this. And this is what the aim of this talk is. it is to make students realize that we need to unearth these inequalities, and we need to bring this to fore so that and we need to think of solutions to come out of this, balance of power, equation of power that we have, that is existing in the world today.
Does that answer your question, Dr. Aditi? You have a follow-up question? No. Okay. I think if there is no further questions, we can wind up. So thank you very much, Aditi. It was a very, very informative session. I think you have sown seeds for knowledge production in each one of us, and it is for each one of us to take up the responsibility to take the initiative and engage in active academic debates. And like you said, it is a process. Like even if it is the politics of paper publishing, and so you have to be so active that you have to break all barriers in knowledge production, where you can become an academic authority, where your voice is heard in the international community, and be a prominent force in the epistemic community that is controlling knowledge production in the international law sphere. So thank you very much for this very, very insightful session. I'm sure all of you are enlightened by the new insights that Aditi provided. I've shared Aditi's email ID with all of you involved in the webinar. Please feel free to ask your questions to her or give any feedbacks. I'm sure she would appreciate it. So looking forward to more associations with you, Aditi. Thank you so much for taking time. Thank you, Dr. Aditi, and I also thank Dr. Bismi Gopalakrishnan and all the participants who actively participated. Thank you very much for all the questions. Thank you. I wish you all a very happy and nice weekend. Bye.
Thank you so much, and I apologize for the constant interruptions on my end.
That's okay. That's okay.
Thank you for being patient throughout, and I would love to hear your comments, your feedbacks, anything you want to convey to me. Ruben has shared my email ID with you, so please connect and let me know. Thank you so much, Ruben and Dr. Aditi and Dr. Balakrishnan, for providing me with this opportunity. Thank you.
Thank you. Thank you. Thank you, everyone.